Thomas. I will be arguing today that there are accumulation of the errors, and I'm just going to get right into what those errors were. In this case, trial counsel's closing argument left the defendant denuded of a defense. Trial counsel in this case made several concessions which were tantamount to an admission to an indecent assault and battery, and Mr. Thomas was in fact convicted of an indecent assault and battery. There were a number of statements at multiple points in the closing argument that where trial counsel conceded, and actually used the word conceded, I concede to you, ladies and gentlemen of the jury, that the defendant's conduct was inappropriate, unacceptable, certainly unwanted, possibly offensive. And I've cited those.
Do you disagree with any of those contentions?
In terms of whether
you disagree that it was unwanted, inappropriate, what your client did?
I think the issue is whether through the jury's eyes, how that argument would have played to the jury. This was the trial counsel's opportunity to give a summation and marshal the evidence in favor of his client.
My understanding of the way that this case was presented to the jury is that the case for non-consensual contact was pretty strong, including a surveillance videotape that demonstrated the actual contact. And the theory of the case that you contend now is manifestly unreasonable was to roll the dice on an all-or-nothing strategy to eschew the possibility of a compromise verdict for simple assault and battery, and to focus on the element of indecency. The argument that you're challenging right now is an acknowledgement to gain credibility with the jury that the contact took place, that it was in fact unwanted, but to focus their attention on the element of indecency and to argue, as defense counsel did over and over again during the closing, that while it may have been inappropriate, unwanted, it wasn't indecent. Isn't that all of the same piece?
Well, I think that question really addresses the second argument in my brief as well. In this case, trial counsel initially requested a lesser included offense instruction of assault and battery. And
after consultation with the client, decided that their best strategy was to acknowledge, as the videotape depicted, that there was in fact contact, but to say that it wasn't indecent.
Well, in terms of the record evidence of the consultation with my client, there's actually record evidence that supports that does not support that, and that I would point to trial.
Well, the judge made a finding, right?
The judge did.
And we're reviewing this on the record of the judge's memorandum decision on the motion for new trial.
Yes, part of that.
You're contending that finding was clearly erroneous, or simply that there was record evidence to support a different finding?
Well, I would argue that it was erroneous based on the record evidence. There is an affidavit from trial counsel indicating when that conversation with Mr. Thomas occurred, that conversation to withdraw the lesser included offense instruction. The trial counsel specifically points to a moment in a cell after the conclusion of the evidence before final instruction to the jury when he had a discussion with Mr. Thomas, and that, as the trial counsel puts it, the final decision was made to go for the all or nothing approach and to withdraw that instruction. Right. However, when the trial resumes and it's on the record, the trial judge specifically asked the trial counsel, would you like me to give a lesser included offense of assault and battery or not, because the judge indicated she was inclined to before that recess. At that point, trial counsel turns to Mr. Thomas and says, what do you want to, pretty much he says, what do you want to do? The decision is yours, you have to tell me now. Mr. Thomas says on the record, ask for it. At that point, the trial counsel asks for it. Then the jury comes into the room. There's never a break in the record. And then right before closing arguments are about to begin, trial counsel approaches the bench and asks to withdraw the lesser included offense instruction. And Mr. Thomas was not present for that bench conference.
He wasn't present at the bench conference, but he was present with counsel at the trial.
He was.
It is, now, as we go through, I don't need to sort of remind you of what we consider when we evaluate credibility determinations made by a judge or findings of fact, but it is at least a permissible inference for the judge, hearing all of the record evidence that you've recited, to infer that counsel had a consultation with his client in the jail cell and at counsel table.
Where does it say this happened in the jail cell in the affidavit?
Pardon, Your Honor?
Where does the affidavit say this conversation happened in the jail cell?
In trial counsel's affidavit, which I can point to the record site, the record appendix site, if I just have a moment, but trial counsel, I attached an affidavit from trial counsel. If I may, with respect to that, the
bottom line is that you're launching an all-out assault on the trial judge's finding of fact that trial counsel averred.
I see.
Yeah.
I see.
Thank you.
Trial counsel averred that he made this decision based on the instruction of his client, and you're faulting the trial judge for crediting that assertion and making a finding to that effect.
I am indicating that there's record evidence that contradicts that assertion.
Well, I understand that there's record evidence, but the question is whether that record evidence irremediably makes that finding clearly erroneous.
I am asserting that it was clearly erroneous because trial counsel does not state in the affidavit that final decision was made at trial counsel in consultation or at counsel table during the trial. He said it was made in the cell.
But the judge who heard the motion for new trial also presided over the trial, right?
Yes.
Okay. I don't need to remind you of this grade of the hill that you're trying to climb here, but it is a steep one.
Thank you, Your Honor. Your Honor, I'll just, if I may, just I'll leave that point aside and move on with the permission of the court.
Let me just ask one question, and this is I'm sorry to come out of the blue a little bit here, but I noticed one argument that the motion judge addressed in the memorandum of decision that apparently was made at the motion for new trial that is not repeated here on appeal, if I understand things correctly, and that was a complaint about misstatement of the evidence by the trial prosecutor. The trial prosecutor characterizing the nature of the contact in a manner that rather graphically illustrated the indecency, but doesn't seem to be borne out by the testimony at trial. Have you abandoned that argument?
In terms of the misstatement of the evidence,
Right.
Your Honor,
I don't see it in your brief.
Yes,
Am I misremembering the nature of the motion for new trial?
No, Your Honor is not.
Trial counsel?
Was I trial counsel?
You were new trial counsel?
I was appellate counsel, Your Honor.
I know, but on the motion for new trial?
Yes, I brought the
okay,
motion
that's
for
what
new
I thought.
trial.
Okay.
Yes.
So
yes.
you made that argument for the motion for new trial, but you're not making it here?
I did not include that argument in my brief, Your Honor. I focused on the other arguments that were made. There were many that were made in the motion for new trial. I selected, I did not select all of those to brief at this level.
Selecting the best issues is definitely what an appellate lawyer should do.
Right.
And is one of those, is one of those arguments made by the prosecutor that you believe should have been objected to, the comment about it being monstrous conduct?
Yes, I did include in this brief the fact that there were improper arguments made by the prosecutor that were intended to inflame the jury. One of those comments was the fact that Mr. Thomas's conduct was monstrous conduct. I think probably the more serious language used by the prosecutor is the fact that the language about the objectification of women. This was a case about an argument about whether an indecent assault and battery occurred, and the prosecutor started referring to about the objectification of women and how Mr. Thomas was treating women like objects and how monstrous is that. My argument is that in this climate, this contemporaneous Me Too climate where there is a very large societal response to conduct that involves sexual or perceived sexual conduct toward women.
But the nature of the interaction, not simply the contact that gave rise to the charge, but the defendant's behavior following the women down the street and the comments he made. I mean, the prosecutor is allowed to make arguments grounded in the evidence, and the defendant's behavior at least strikes, I mean, my eyes as being consistent with the objectification of women.
Well, I think the argument that I'm making is that that is a comment that is designed solely to incite the jury to a verdict, to emotionally connect with the jury and move them in your favor, to move them toward a verdict of guilty. It has no other place in this case.
Isn't that what the prosecutor's job is?
Yes. However, it's not based in the facts. It's not. This had nothing to do with whether or not an indecent assault and battery occurred. It had to do.
I thought one of the elements of indecency judged the conduct by reference to societal norms.
Yes, that is true, contemporary societal norms. But the, I guess, categorization of this or characterization of this as the objectification of
If the
women.
evidence is consistent with objectification, and objectification is consistent with one of the elements that the prosecutor has to establish, I'm having difficulty seeing why that's not fair use of the evidence, marshaling toward the theory that the prosecutor is charged to develop.
Yes, Your Honor. I think that what it does is it puts the jury into a mindset of not looking at whether the facts meet the definition, the legal standard of proof for an indecent assault and battery. It moves them into thinking about the political maybe correctness of this action or that action, and maybe the emotional response that they may have to a man objectifying a woman, as opposed to whether Mr. Thomas committed the conduct that was alleged to have been committed, and it moved them out of that sphere and into a sphere of emotion. Which
Now, if all of that is so, what do we make of the fact that the jury acquitted the defendant of a couple of the charges? So they clearly weren't swept by emotion by an over-the-top presentation by the prosecution. They appear to have looked at the video and evaluated the testimony, the evidence before them. Isn't that a fair inference?
Well, the one charge that they did convict on was the charge against RB of the indecent assault and battery. The other woman did not testify at trial. The woman identified by initials as SH, she did not testify at trial. So it's not really a surprise that the jury acquitted on that count pertaining to the woman who did not testify at trial. In terms of the threats, they did acquit on the threats charge against RB, but they convicted on that charge that really did invoke the argument of objectification of women, and my argument is that had no place in this trial. In terms of the video evidence in this case showed a very brief contact. There was 72 seconds in length, the entire interaction. It was inside a crowded store, a very small setting in a store. Everyone was fully clothed, and the video evidence does not rise to the level of the seriousness of the offense that RB testified to at trial. So the video evidence, if anything, I would argue to the court, detracted from the evidence in this case. I think it shows that this case is far from overwhelming, and when the court is evaluating the errors here and applying the standards, I ask the court to keep in mind that given the evidence, the video evidence, that this case was far from overwhelming in terms of proof. And so
At least on the indecency.
I'm sorry, Your Honor?
At least on the indecency, if not on the assault and battery.
But the assault and they weren't given the option of an assault and battery. that was taken from them. And for that reason, that is my point as to why this was a manifestly unreasonable strategy in arguing in closing argument that the conduct was inappropriate, offensive, and by definition, from Merriam-Webster, indecent is a grossly improper or offensive, inappropriate, unseemly. That's the definition of indecent. Thank you. I'll rest on my brief if there are no further questions. Thank you.
Good morning, Your Honors. Erin Knight on behalf of the Commonwealth, asking this court to affirm the defendant's conviction. I want to start with the overall concept here. The overall concept of this entire trial was the video caught the defendant's act so the jury could see it, and the defendant did not want to be convicted. And here, that is the trial strategy that was employed, the all-or-nothing strategy in the context of the evidence as it was given to this defendant, given to this defense attorney, and what they could actually do with that evidence.
Within that strategy, I mean, you heard my questions of your sister a moment ago, but the word she closed with, observing the adjacency, if not similarity or identity of inappropriate with indecent. Why did that help? Why did acknowledging that the contact was inappropriate, improper, why did that help? I understand acknowledging what the video clearly showed.
Correct.
Was necessary in the context of this trial. But why was it necessary? Why was it appropriate? Why was it helpful to acknowledge or to assign the label inappropriate or improper?
Because it was inappropriate and it was improper.
Well, if you accept the Commonwealth's theory of the case, it was indecent. But
Absolutely, Your Honor.
If we're trying to ward off that conclusion, how does acknowledging that it's inappropriate help?
Sure. So I want to start off with acknowledging the fact that it was conceded that the defendant did in fact make contact with the women, and it is shown in the video. So you have at least an assault and battery by concession. So when they focus on
the whole theory of the case.
So when they focus on,
we're going to take that off the table so the jury can't return the easy verdict, and we're going to ask for a not guilty.
For an all-out acquittal. Correct.
Okay, let's go back to the question of how does it help in furtherance of that approach to acknowledge the contact, but then go on to the next step of acknowledging its inappropriateness?
Because what the trial attorney was trying to do here, as Your Honor had said earlier, was he was trying to get credibility with the jury, right? The jury could see that this contact was happening. It was unwanted. It was clear it was unwanted from the behavior of RB, but also from the testimony at trial that it was unwanted.
Consensual is an element of simple A and B, but not of indecent.
Correct, but it also shows that the testimony that she could feel his groin area rub up against her. Okay, so the way to combat that would be to be like, yes, she didn't want this. Yes, it was inappropriate. He tried to marshal it to say that it was more of a dance club or a bar setting would be more appropriate for this type of behavior. He tried to characterize it as flirting. But what he was really doing was he was trying to state that while the touching was not disputed, the touching did not rise to the level of what would be considered indecent under the law. And by using terms of things of not appropriate and things like that, he was taking it into that realm of, yes, okay, this isn't exactly what should have happened, but it didn't reach to the level of the legal standard of indecency. And if I would just point back to the motion judge's decision here, who was also the trial judge, and went through this at length with them about the assault and battery, lesser included, and the indecency at trial and the strategy at trial. And in her decision, in the record pages 114 through 117, she talks about this in great length. And she said it wasn't unreasonable for him to try to persuade the jury that he was fooling around or joking with the women. It wasn't unreasonable for him to try to exhibit this as flirtatious rather than lewd behavior that these women are trying to characterize to the jury now was inappropriate or indecent. So by asserting that the nature of the defendant's behavior was in fact unwanted or inappropriate, that did not reach the level of indecent. And that's really what he was left with here. That video, her testimony, what happened is all before the jury. And in order to go for that all or nothing strategy, in order to downplay that conduct without discounting it completely, that's really what he had to do. He had to get that credibility with the jury, and really that was kind of the only way that he was able to. Otherwise, he would have been admitting to crimes that the defendant didn't want to have or didn't want convictions on. And I think that it is very
troubling to me, Counselor, that, as you say, defense counsel has this very fact-based, sober argument about the elements, and the prosecutor responds with, I mean, I know we can do hyperbole, but it's pretty hyperbolic.
Sure.
Ultimate act of objectification, how monstrous. I mean, this is someone assaulting two women in a convenience store, very bad, but I wouldn't think rises to the level of monstrous. I mean, how do you justify that if you do?
Sure, Your Honor. I respectfully disagree. I do think it is monstrous. And I do think that characterization, it was a notion. She was not calling the defendant a monster, but the objectification and using these women as his own gratification, certainly against their will, as she's here testifying to, is a monstrous notion. I think that, yes, the societal norms around Me Too and, that recognition and that understanding was coming more to light and is still coming more to light to this day, but I do think it is a monstrous notion that a man would be able to just come up and objectify these women by rubbing himself against them in a way that is, if anything, indecent, by rubbing his groin up against this woman who had nothing to do with him, didn't know him. There was no reason for this act in a convenience store while she's getting off work and trying to get some cigarettes to go home. This was a monstrous act, and I think that we all know that the prosecutor is allowed to marshal the evidence, to support the conviction in the way that it came out. And the way that it came out was R.B. did believe this to be objectification. It was unwanted, and quite frankly, it was monstrous that this just happened to her against her will, and it was indecent. And I think that where the prosecutor can use hyperbole, can use the evidence to marshal it in the way that the jury will understand the nature of the act, I think this was entirely appropriate here.
What about the issue that the defense raised about the failure to object to evidence regarding the defendant not cooperating with the police?
Sure, Your Honor. So I'd like to start with the fact that the silence, there was no invocation of silence, and I think both the motion judge and the record will spell out that he was being belligerent and uncooperative. He wasn't necessarily making any statements or gestures that would indicate that he refused to speak to police because of any charged conduct or any accused conduct, or he was failing to speak with police because he was invoking his right to silence. He was being belligerent. He was being uncooperative. He did eventually give his name and give his information to the police, but the way that the police characterize it, and this is borne out both through the testimony and in the motion judge's decision, is that he was just being uncooperative. He wasn't invoking his right to silence, and as the law in this Commonwealth states, for a police officer to know that that's what's happening, there has to be some invocation, and there was no invocation here.
Well, Officer Sullivan says he was argumentative, which is the opposite of invoking your right to silence, but Officer Levichev says he refused to talk to me, which sounds more silent.
Sure, but you can go on to read that both. So you have to take the context of the entire conversation, and you have to take the entire trial transcript of both officers describing that interaction. And if you take it in context and don't just parse out the single pieces, you see that what was really happening was he was being uncooperative and belligerent. And I think that he was trying to avoid speaking to police, but it wasn't in a I did something, so I'm not going to talk to you. It was just he was being uncooperative. And I think the trial transcript and how it comes out at trial, and if you couple that with the nature of R.B.'s testimony about how he was acting towards her, I think it's clear that he was just being belligerent at that point. So if the court has no further questions, I will rest on my brief.
Seeing none, thank you both.
Thank you.
Thank you.
Brings us to the third criminal case on our list for hearing this morning, case number 2021-P23, the Commonwealth versus Jaheel J. Robinson. And just as a reminder, we will take a brief recess after the conclusion of the argument in this next case.
May it please the court. Good morning, Your Honors. Jennifer Peterson here today on behalf of Jaheel Robinson. Perhaps the single most distinguishing feature of our criminal justice system, Your Honors, is the fact that our Constitution requires the prosecution to prove beyond a reasonable doubt that the defendant is guilty. Abusive head trauma and shaken baby syndrome cases flip that script. In those kind of cases, before the trial even commences, medical professionals are allowed to claim that a child's injuries are non-accidental, and the burden shifts to the defendant to prove otherwise. Tellingly, in the instant case, the defendant argues that the Commonwealth did not meet its burden of proof here with respect to Cameron's injuries. And tellingly, the Commonwealth even seems to acknowledge that. In its closing argument, it said, "As I said in my opening, the Commonwealth is not able to give a specific mechanism, only to be able to say to the court that the explanation offered by the defendant is not consistent with the injuries." So in other words, Mr. Robinson failed to prove that he didn't intentionally injure his child. This case turns on the sole issue of whether or not these injuries were inflicted intentionally or accidentally. And
Well, I mean, I understand the theory that you're trying to pursue of burden shifting, but this is really not that far different from any other case that turns on inferences and circumstantial evidence.
But I would say it is different, Your Honor, in that the inferences are the inferences that arise from medical conclusions.
Well, medical conclusions, but also the evidence that is and is not present. And it's fair game, without shifting a burden, to observe that there is no contrary evidence to contravene the inference that the prosecution is asking the jury to draw.
But it's the Commonwealth's burden, I would suggest, Your Honor, to present that evidence. The defense has nothing to push back against. So here, the Commonwealth just says, well, there's a constellation of injuries here, and we've decided, the medical professionals, some medical professionals, not all medical professionals, the prosecution's medical professionals have decided that that cluster of injuries could not have happened accidentally, or probably couldn't have happened accidentally. They possibly could have happened accidentally. I think all but one of the experts said that it's possible that this happened accidentally. So,
Yeah, but wouldn't your argument have more force if the defendant actually didn't put on a case? But here, the defendant put on a case, put on his own experts,
yes,
and we have as a classic battle of the experts, where you have the prosecution experts and the defense experts, and the jury apparently sided with the prosecution experts.
well, it was a bench trial, Your Honor, respectfully.
I'm sorry.
But there is a battle of the experts here, and, you know, the old canard, if two things have been equally proven, then neither can be said to be proven, and that should go to the defense in that instance. A lot of this, what took place here, is beyond the ability or realm of legal professionals. This is a lot of this, and this case was difficult, I'm sure, to read because there's a lot of medical information in it. Essentially, we rely on these medical professionals in order to make a determination of whether or not we can infer that it was accidental or intentional. And I would just say that the default should go to the presumption of innocence. That's the way our legal system is set up, for the presumption of innocence. And here, like I said, it flips the script. These cases have a presumption of guilt. Once the medical professionals indicate that they don't believe that these injuries came about accidentally, as the defendant said.
The defendant walks down the stairs with the child, and after that, the child is horrendously injured, and the doctors, all the Commonwealth doctors say there's no way this could have happened from a fall down the stairs. It's more like an 11-story building fall, and its abusive head trauma is the most likely explanation. So why isn't that enough evidence that your client did something terrible to the child?
I would suggest because the medical evidence, the defense first put on opposite experts that said that
Evaluation of the weight of those competing evidentiary presentations is for the trier of fact, not for us, right?
That's true, Your Honor. However, with this, every single one of the, with the exception of one of the doctors who didn't seem, just to back up a bit, all four of the Commonwealth's expert doctors seem to misapprehend a lot of the details from which they drew that conclusion of that it couldn't have been an accident. They were unaware of how far the fall was. They were unaware of.
Well, Dr. Wilson says 11-story building. There's no evidence that the child was dropped 11 stories. Dr. Mantagos says it's like a television set falling on a child's eye. No evidence of that. Dr. Robson says inconsistent with a small fall. Maybe your view is that it was a slightly bigger than a small fall, but I got at least two experts that seem to have completely inconsistent with the defendant being in the basement.
Those same experts, Dr. Bertocci said she agreed that a child can die from a fall of 3 feet or less. Dr. Wilson said that accidental head trauma could be the cause of both the injuries to Cameron's brain and the injuries to his retinas. And Dr. Robson said, you know, when asked if the injuries were consistent with the fall, she said it would depend on the height of the fall and the surface onto which the infant fell, adding that the level of injury of this case could have been caused by something other than acceleration, deceleration, and that she couldn't rule out a fall.
The thing I keep coming back to, as I listen to each of your protests here, is that all of this is fair game for cross-examination of the experts and for argument to the trier of fact. The trier of fact, hearing the competing evidentiary presentations, performed the task that is quintessentially their prerogative, to weigh and assess and resolve inconsistencies and to come to a conclusion. If what you're arguing is that no rational trier of fact could have reached the conclusion that this trier of fact did, then I need to hear that. But so far, that has not been the direction of the arguments that you've made.
Well, yes, Your Honor, I would argue that the trial judge erred in making the determination.
No rational trier of fact.
No rational trier of fact.
Viewing the evidence, the light most favorable to the Commonwealth, and drawing all inferences in their favor under the Lattimore standard, could have resolved the conflicting strands in the evidence to conclude that this was intentional rather than accidental.
Yes, I would argue that, and I would argue that because I do not believe that the Commonwealth presented sufficient evidence from which the judge could infer that. And this is clearly based on circumstantial evidence. The Commonwealth admitted it doesn't know how these injuries happened, which makes these cases particularly difficult. And so, I mean, the thing is, due process requires that the state disprove the defense. disprove. And Mr. Robinson's defense was that it was an accident. The Commonwealth failed to disprove this defense of accident. The Commonwealth admitted it didn't prove anything.
If the Commonwealth proves intent, that disproves accident.
I would
the question of whether the Commonwealth proved it or not is a question of whether it was rational to infer intent from the evidence that was presented.
And I would suggest it doesn't, Your Honor. I mean, even putting aside all the differences between short falls and long falls, and, who measured the distance, or was it even measured of the steps, and the kind of surface that it fell onto, even the experts agree, Dr. E, I thought, you can clearly tell that there are injuries, but not whether the injury happened accidentally or intentionally, just that there was an injury. So it is left to the rest of it. And with
no, it's not just that there was injury. You also can assess the nature and scale of the injury, right?
Well, the scale of the injury, I don't think the scale of this particular injury, I mean, it's clearly a traumatic injury. It's clearly a life-altering injury.
And we look to medical professionals who have experience in assessing injuries to draw some guidance on what could have caused the injury.
But I would suggest, Your Honor, even the Commonwealth's witnesses said, we don't know
No, of course
sure.
not. Of course they don't. Of course they don't.
So because
They can do is offer their best guidance on the evidence that they have to review.
And that's why, some of the cases that I've cited in here have a lot of, I mean, the legal system is clearly struggling with these cases because the medical professionals have not yet resolved some of these issues. These seem to be in a state of flux. And
But the Commonwealth's case didn't rely entirely on medical evidence, did it?
Primarily on medical evidence.
Wasn't there other evidence about the relationship of the parties here, that they were in turmoil?
I would say that that's hyperbole, Your Honor. I don't believe it would be.
Wasn't there evidence that 5 days before this happened, the mom said that she did not want to be with the defendant anymore?
And didn't the mother testify?
I believe there was a text to that extent, but there had been texts previously. The couple was working out issues. They
Didn't the
argued
mother
back and
testify that
forth.
she punched the defendant over his care of the child?
Excuse me?
Didn't the mother testify she actually punched the defendant over his care of the child?
I don't recall that particular testimony. It might have been, but she also testified that he was never aggressive with her or the baby. She did not want to, she also testified she did not want to go home. She wanted to be where she was, living in his parents' house. So I think those are really red herrings in this case. The question isn't whether, the status. I mean, to say that he was, even the state trooper who investigated said she found no reason that he would want to hurt his child. They're just simply, it's grasping at straws to say, oh, well, the couple's having some relationship issues, and that's why he somehow injured his child.
He texted that he thought the baby hated him.
These are young parents. It's like the baby loves you. I think the baby likes you more than the baby loves me, because, and it was said in the context of, I think diaper changing and stuff.
It just hurts.
Correct.
He hates me. It's heartbreaking to me.
Oh, okay.
That's what your client said about this child.
That's what his ex-fiancée said about it, yes. But that's in the context, that's taken out of context. It's taken in the context of the baby is crying when he's doing diaper changes. So the baby, doesn't like that he's having to do essentially the dirty work, the stuff that makes the baby cry, diaper changes and stuff like that. So she gets to cuddle and nurture and feed, and he gets to do diaper changes and the like. So it was just said in that context. So I would suggest that to say that constitutes some kind of reason for him to severely brain injure his child is a red herring. And with respect, I did want to touch, before my time is getting very short, upon the idea of this bruise. The idea of the ear bruise, even if the court finds that somehow there was sufficient evidence to find him guilty of that. It's certainly not an injury that was it was a substantial impairment under 13JA. The fact that it was gone within 2 days, it wasn't even noted. It was first noted on the 10th, and the medical records at the BMC didn't even note a bruise on the ear, and Jessica said the bruise was gone. And the doctors, curiously, I mean, I've seen the picture, but the doctors only saw, one of the doctors that testified that this had to have been an intentional, it couldn't have been an iPhone, didn't hold a third of the pound iPhone, didn't see the bruise in person, only saw, we don't know the kind of quality of the printing. She just saw a picture of a bruise and said, yep, that had to be intentional, versus two physicians who saw it in person that said they thought that what Jahil said happened when he dropped that phone was consistent, could have been consistent with the injury that was seen, the bruise that was seen. And
Counselor, if you're right that it's not, doesn't rise to the level of injury as defined in the statute, the proper remedy is to enter an assault and battery, correct?
that would be true, but of course, Mr. Robinson would argue that there is insufficient evidence for any of these convictions, Your Honors.
Thank you.
Thank you, Your Honors.
For the Commonwealth.
Good morning. May it please the Court. Laura McLaughlin for the Commonwealth. With me here today is the lead trial prosecutor, Assistant District Attorney Lisa Beatty. There was abundant evidence that the defendant intentionally inflicted substantial injuries upon his 4-month-old child, which resulted in the child's permanent blindness, severe developmental delays, and traumatic life-altering brain injuries. Contrary to the defendant's arguments, it was within the judge's exclusive providence as the sole trier of fact to reject the possibility of accidental injury and determine that the medical evidence and reasonable inferences put forth by the Commonwealth were sufficient to prove that the child's injuries were intentionally inflicted. I'd like to call Your Honor's attention to a quote that is cited in my brief on page 32 and made by this court in the case Commonwealth v. Roman, which is a 1997 decision. This case stands in the not particularly unfamiliar posture of a child left in the custody of an identified adult who suffers injuries of a type that are inconsistent with the explanation given by the custodian and not attributable in circumstances to ordinary accidental injury. That is a case that this court decided in 1997 where the defendant's account was that he accidentally burnt a child in the bath and that the medical evidence put forth established that those injuries were intentionally inflicted. Here, the Commonwealth put forth 4 medical experts who all opined that the child's injuries were inconsistent with accidental causes and more consistent with acceleration and deceleration forces that are indicative of abusive head trauma. As Your Honors are aware and familiar with the briefs, I won't outline all the medical injuries in detail. However, the experts were able to account that a number of these injuries were highly uncommon and not accounted for by vertical falls, such as the retinoschisis and the tear in the bridging veins of the eyes and brain are types of injuries that require significant acceleration, deceleration forces, or rotation or angular forces. The doctors in these cases noted extensive, too numerous to count injuries within the retinas, as well as numerous non-contact subdermal hematomas in the child's brain. There was also neck and spine strain injuries that a reasonable inference would have been caused from a violent to and fro motion or a type of shake would have caused the strain on an undeveloped 4-month-old infant's neck. I would dispute with defense counsel's representation that the Commonwealth experts were unaware of all the circumstances. These experts knew all the facts of the case. They knew all the medical evidence. Their decisions were not quick judgments. As the medical experts testified, they are trained not to presume abuse, but rather to explore all alternative explanations or pre-existing medical conditions, with this child had none. Their decisions came after they considered all clinical data, including numerous CAT scans, MRI, skeleton studies that occurred over a period of months. In addition to these experts' opinions and medical testimony, these injuries all occurred at times when the defendant was alone with the child. They also occurred during a period of tension between the defendant and the child's mother. They were frequently arguing about the caretaking of the child. The defendant was insecure about his ability to care for the child and made statements that he believed that a 4-month-old infant hated him. And it also occurred, the traumatic brain injuries occurred at a time that the mother was making steps to distance herself from their relationship. Days prior, she told the defendant she no longer wanted to be in a relationship with him and was taking steps, including buying her own car, which the defendant had no involvement in and occurred hours before the traumatic brain injury, to further distance herself from the relationship and to gain some independence. Turning Your Honor's attention to the ear injury, all of the Commonwealth's experts, and it was undisputed that an injury to a 4-month-old child's ear was extremely unusual and highly concerning, as depicted in the image that was put forth as an exhibit to the trial judge and included in the Commonwealth Supplemental Appendix. This bruise, the photograph was taken on the day of the injury. It was not a small bruise, as the defendant references in his brief. It is a large, deep purple bruise that extends from the inner ear to the outer ear. Just looking at it, a reasonable person would not expect a fumbled cell phone to cause such a significant and serious injury to a child's ear. Looking at the statute of what a bodily injury would require, a 4-month-old infant would not be able to self-report pain. However, a reasonable inference would be that the location of the bruise and the severity of the bruise would have caused difficulty for the child to hear. He was
What
extremely...
is the evidence in the record that we can look at that will support that description of the seriousness of the bruise?
Yes. The medical testimony is, I believe, at one of the hospitalizations, either at Children's or BI, when he was being treated for the stomach illness, and the mother's testimony was that the days following this bruise, he was extremely irritable. It could be inferred that he was extremely irritable because he had significant pain in his ear. The location of that bruise, an inference would be laying your head or resting comfortably for a child, that bruise would have caused a serious pain.
Irritability is now one of the indicia that we use for serious bodily injury?
In a 4-month-old infant who's unable to vocalize or express pain, the only way...
Well, we could use the physical manifestations of the injury. If there is abundant swelling, distension, displacement.
There is. It says...
But a child who has a mosaic of different physical ailments, who is irritable, it's hard for me to see that as suggesting that a bruise on the ear, without more detail, describing the nature or extent of the bruise, is serious bodily injury within the meaning of the statute.
Well, I'd say under the statute, the Commonwealth must prove that it is considerably or significantly compromises the usual function of that body part.
Right.
And
so there is not, I understand the challenges for the Commonwealth in establishing that element with a nonverbal victim.
yes, but I would assume that...
One of the impairments would be if the child can't hear. We don't know that.
Correct.
One of the indicia would be if there was significant distension or swelling. The record that I have available doesn't show me that.
I would suggest that the way that the injury is depicted in the photograph, an inference would be that it would cause significant pain to a child.
Where's the photograph?
It's in the addendum, and I believe in the Commonwealth Supplemental Appendix.
Page 3 of the Commonwealth Appendix.
Look-
You keep saying pain, but the statute doesn't say anything about pain. Substantial impairment of the physical condition, fracture, subdermal hematoma, injury to internal organ, repeated harm to any bodily function or organ.
So for the repeated...
And if you could say, even if it was an adult who could say pain, that doesn't seem to fall into the statute.
Yes, I would say the severity and the location, a reasonable inference could be that it was a result of a repeated harm, such as a pulling or squeezing to the child's ear. Because the evidence before...
Okay, why? You just said that, but that's not in any of the experts. How do we know that that has to be repeated to cause that injury?
Because the inference
get
that was
repeated.
given, that it was an accidental dropped cell phone. The Commonwealth had experts that looked at the biomechanics of the cell phone and different fault.
I know
and
the
found-
cell phone didn't do
We're
it.
moving away from cause
Yes,
to severity.
yes.
But you're saying it had to be repeated, and I don't see anything that tells me that it would take multiple pullings to cause that injury.
Correct. It could be one act that caused.
It could be one impact. It could be one particularly significant pulling or grabbing, squeezing.
Yes. But for the trier of fact, looking at all the reasonable inferences put forth by the Commonwealth, there was sufficient evidence to establish that it met those elements. And the
As
Commonwealth.
to cause, yes, I'm still trying to get at the serious bodily injury element.
I would,
An impairment of the ability to use the ear for its intended purpose, or to impair the ordinary function of the child.
well, I think the child's hearing would have been impaired by that location and severity of the bruise. It looks swollen on the inner area. It's bright dark purpled on the exterior area.
Was there a medical I'm looking at the picture
No,
now.
there was
Thank
no
you for
medical
that.
testimony. That the medical testimony.
I can't tell
No.
as a layperson from the picture that
The medical
bruise
testimony
would have impaired the
was
child's
that a
ability to hear.
bruise on a child's ear is highly concerning and is a very indicative flag of abuse, because a bruise is not an area
We get that there.
Yes, but just the way the ear is shaped, and there's testimony about this, it's not a part of a body that bruises easily. It's not like a shin. It's
We get that it was an inflicted injury.
But the
Question
severe-
is whether it impaired the child's ability to use the ear or otherwise impaired the child's ability to function.
And I think the reasonable inference has to be made that it was. The child was extremely irritable following this injury. The child, and it's not just irritability alone, the child does not have words to communicate. The child was in pain. He expressed that pain through his irritability. An inference to be made is that location, if a child's laying down, that would have caused additional substantial pain by trying to rest your head comfortably as an infant would be doing.
Was there any connection between the episode of vomiting that followed this injury?
They are all close in time. I do not believe that there was that's a medical judgment I could make.
I mean, in the evidence, was there any connection in the evidence connecting the injury
They
to
were all
the ear
clo-
to the severe vomiting that followed?
There was no medical opinion that linked them, but they all occurred at the same time, close in time. The medical testimony and the mother's layperson opinion was, they called it a stomach virus, but the child was dehydrated and had a number of were they manifestations of other acts or other injuries? That is not what's before the court or what I can attest to.
In the presence of an apparent stomach virus, the vomiting would be more naturally associated with the stomach virus than with the ear injury, correct?
Correct, but the ear injury could have been indicative of other intentional abusive acts, other shakes that occurred prior, and the stomach bug. So it's all part of,
I'm simply getting,
yes, Your Honor, yes.
tell that I'm struggling with the question of whether the ear bruising satisfies the statutory test.
Yes, Your Honor, and I would suggest that all the constellation of injuries put forth by the trier of fact and all the expert testimony about that bruise, as well as all the traumatic brain injuries, that the evidence was sufficient. In addition, the judge was able to infer absent of mistake or accident, as there was evidence of prior bad acts committed by the defendant, including red marks on a child's back, as well as defendant moving the child in legs in an odd motion that alarmed the mother,
I hate to bring you back,
yes.
but I just need to check. Do you agree with your friend that if the bodily injury is the only thing we find insufficient, that the only lesser included we have here is assault and battery?
Well, assault and battery on a child, yes.
Is there an assault and battery on a child without bodily injury? I didn't see that.
I would have to look back on that, but the lesser included would either be the assault and battery.
So could you do me this? If you find a lesser included that is other than assault and battery,
Yes.
please let us know.
Yes, Your Honor, thank you.
And the ear is the only thing? What about, we heard about traumatic brain injury.
Yes.
Why wouldn't that suffice?
It did. I thought he was
Separate
convicted of
separate charge.
two counts, and found not guilty for one. And unless your court has any other questions, I'd rest on my brief and respectfully ask you to affirm the defendant's convictions, as the judge was permitted to discredit the defendant's account of accidental injury and find that all the injuries inflicted upon the child were intentionally made. Thank you, Your Honors.
Thank you. We will be in recess. We will resume at 11 o'clock.
All rise. Court is now open. Please be seated.
We resume our hearing list with the first of our three civil matters, case number 2022 P447, Parker Hayden versus Brian McKeon.
If it may please the court, the plaintiff appellant, Parker Hayden, pro se.
Why don't you move the microphone a little closer to yourself? And just for those in the gallery, the plaintiff has filed a motion to be allowed to argue from counsel table, which the panel has allowed.
A fraudulent concealment of a cause of action claim is itself a separate cause of action. Then the underlying medical malpractice claim, the plaintiff at one time had a right to bring. That right was violated by the defendant's fraud. It's a separate claim. Every single aspect of the two claims are distinct. This court in Chase v. Curran has already held that the claims are distinct, that the claims are separate causes of action.
The claims are distinct, Mr. Hayden, but they arise out of the same underlying facts. Is that correct?
Perhaps the same operative facts,
Right.
I would say.
And the difference between Chase v. Curran and this case is that in Chase v. Curran, the fraud claim was allowed to survive while the other claims were barred by the statute of repose when they were all brought together as part of the same complaint.
That's correct, Chief Justice. In Chase, the plaintiffs in that case brought forth a fraud claim that was not perfected until amendment due to specificity requirements of Mass R. Civ 9B.
Right.
And they also didn't cite the specific injury, which was the lost opportunity to file a timely cause of action. In fact, the fraud claim itself seems to be almost contingent upon the dismissal of the prior claim of malpractice as the actual injury.
Not really contingent, but civil procedure was one of my least favorite classes in law school. It certainly is among those least intuitive as one receives legal training, because an amendment to a complaint, adding a new cause of action, relates back to the date that the original complaint is filed.
Yeah, for purposes of statute of limitations and so forth.
Right, it's interesting. In this case, had your fraud claim been brought as part of the original complaint, the other causes, the other claims would have been barred by the statute of repose, but your fraud claim would have survived.
Correct.
What makes your circumstances today a challenge for you is that it could have been brought as part of that complaint, but was not, and therefore the dismissal of the prior complaint serves as a preclusion of all other claims that could have been brought originally.
Well, that's the defendant's argument, Chief
Well, it's
Justice.
also the law. It's the way that the civil procedure operates, unfortunately.
Well, I would cite the cases that I've cited in my appellant's brief, that specifically Landrigan v. City of Warwick, where even though a plaintiff could have potentially tried both actions against the defendant at once, he was not required to do so because it's a separate cause of action, and it's not simply enough that a plaintiff could have brought the claim. Personally, I didn't know that this was a legal claim. I couldn't have brought it, but in case law, where the causes of action are separate, then the claim is not barred. There is a limited exception as towards when barring separate causes of action when the transactions are in rapid succession of each other. But I would again point to Landrigan on that, where the fraudulent cover-up of that claim it commenced shortly thereafter. In that case, I believe it was excessive use of force, but it carried on for the years thereafter the fact, and the court held that because the defendant in that case carried on the fraud for years thereafter the original occurrence, even if the plaintiff was able to try both actions against the defendant at once, he was not required to do so, and the claim was not barred because it was a separate cause of action. Furthermore, the plaintiff in this case, myself, is seeking recovery for a distinct wrong. The fundamental facts to be proven in connection with each claim are substantially different. The evidence required to prove each claim is different. To prove a defense of each claim is different. One facts of one claim would not prove the other. the essence of the violation of the legal right is distinct, and the transaction occurrences themselves are also distinct by all the sub-criteria.
So you didn't just raise a medical malpractice claim in the first complaint. You also raised an emotional distress claim based on the concealment and refusal to talk to you afterwards. Why isn't that the same operative facts and the same wrong as what you're raising now?
It would be the same operative facts. It would not be the same wrong. The concealment was used also as a dual purpose for a different regard, even though it didn't toll a repose statute. But the distinction between why this claim is distinct, even though the operative fact was for the fraud that was alleged in the malpractice for different regards, is that the plaintiff in this case is not seeking damages for personal injury, that the plaintiff in this case is seeking economic loss for the lost opportunity to file a timely cause of action, and that because the injury itself is distinct, it's not considered a recasting or a relitigation of the medical malpractice claim.
It's a distinct basis for recovery and a distinct legal theory, and therefore can support a distinct claim, but it still arises out of the same operative facts.
It does, Your Honor.
And it's those claims that must be brought together, all claims that could be brought arising out of the same operative facts, or else be barred by the disposition of those claims that are brought in the original action.
Yes and no, Chief Justice. I would argue that operative facts alone aren't enough to identify the cause of action, which is a requirement needed of claim preclusion. And simply because the claim could have potentially brought is not enough when the identity of cause of action is not met. And separate cause of action.
You were speaking a little quickly before, and I didn't I was focused on your argument based in Chase v. Curran, but you mentioned a case that you suggested stands for the proposition that a case of this type is not barred, even though it could have been brought as part of the original cause of action. Can you remind me which case that was?
Yes, Chief Justice. That case was, I believe, Landrigan v. City of Warwick. And the case in that situation stated that because the fraudulent cover-up was a distinct wrong and the plaintiff was seeking recovery for a separate cause of action, they were not required to try both actions at once. And in the footnote in that case, it outlines what's being discussed here, which is a potential limited exception as towards when separate causes of action are barred. But that's only when the transactions occur in rapid succession of each other, and not in a situation where the transactions, in this case of the fraudulent cover-up, extend for over 7 years past the underlying medical malpractice. Or in that case, it was a different event that triggered the need for the fraudulent cover-up. I would also cite, I believe, Bradford v. Richards, which stands for the proposition that even though a plaintiff could have brought the claim, they were not required to do so, where the fundamental facts to be proven in connection with each claim were substantially different.
But I guess the difference that I see in those cases is that the facts that were pulled in were facts that occurred at a later time.
Not necessarily, Chief Justice. In Bradford, the allegations of the subsequent claim were in fact raised in the prior complaint, although they weren't central to liability of the prior claim, which is the same for this case. They were raised, I think in that case it was a quantum meruet claim and a claim to title based on purported will, but the facts occurred. They cited that even though the plaintiff could have brought the claim, he was not required to do so because essentially the claims were distinct and the fundamental facts to be proven in connection with each claim are different. I would also like to note that the transaction occurrences themselves are distinct. I didn't file a reply brief. I don't think it was necessary because I believe the defendant's argument in this regard is inconsequential, but the sub-criteria of the transaction occurrences, every aspect of that demonstrates that the transaction occurrences are separate. In time, space, and origin, Landrigan v. City of Warwick would demonstrate that, where it didn't happen in rapid succession enough to warrant to be thought as for the same similar transaction. And motivation, it's not actually in the motivation of the plaintiff in seeking monetary damages in civil litigation, but it's rather the motivation of the defendant in the individual wrongs. And it can't be said that the motivation of the malpractice was to conceal the malpractice so as to escape liability. Whatever the motivation of the malpractice was, the motivation for the fraud is different. And convenient trial unit, not only are the two claims inconvenient as a trial unit, it's a legal impossibility that these two specific claims could be held in the same trial at once. Not that the transactional occurrence test matters too much, because where the plaintiff is seeking recovery for a distinct wrong, as is the case here, the defrauding of a patient of a timely cause of action, Massachusetts courts have held that it's a separate cause of action, even if both claims arose out of similar transactions.
Is there a particular reason, and forgive me if you said this, but I just want to be clear on this. Is there a particular reason that you did not bring this claim back in 2019 when you brought the medical malpractice claim? Can you articulate what that reason would be?
Yes, Your Honor. In my situation, I raised allegations of fraud because I raised everything that I thought happened against me, but I didn't specifically label a count of fraud because I was unaware that legally it was a claim that a fraudulent concealment of a cause of action against a doctor for breaching their fiduciary duty to disclose is a separate cause of action that can be pursued. I wasn't aware that this legal claim existed in law, so I didn't raise it because I didn't know that it was a claim. It's singularly embedded in Chase v. Curran, and it might have only been even discussed in the entire United States in Chase v. Curran. So I just didn't know that such a legal claim existed. Had I known, of course, I would have labeled the count. In fact, that's the only difference that Chase did that I didn't do, is they labeled the count for their fraudulent allegations, where I didn't. My underlying malpractice case was more in line with Jocelyn v. Chang, where the fraudulent allegations may have been raised as towards potential trying to toll the repose statute, even though the statute of repose doesn't toll by way of fraudulent concealment. But that's the reason why, Your Honor. I'd like to also state that the identity of the cause of action is not met, and thus the claim is not barred. That's a requirement needed by claim preclusion, and the essence of the violation of the legal rights are distinct. The violation of the legal right for the malpractice claim was the right to adequate medical care rendered, and the essence of the violation of the legal right for the fraud claim was the plaintiff had a right to bring forth a timely cause of action in malpractice, but could not due to the defendant's fraudulent concealment, failure to disclose, intentional misrepresentations. I'd also like to note that the injuries themselves are distinct, that this court in Chase v. Curran, former Chief Justice Raposa outlines the entire case, actually, the distinctions between the two claims, that they are in fact separate causes of action. And because they're separate causes of action, the fraud claim is not barred by claim preclusion by the underlying malpractice claim the plaintiff at one time had a right to bring. I see my time is winding down, so unless there are any further questions of the court, the appellant rests on his brief.
Thank you. Very well presented.
Good afternoon. Tory Wiegand on behalf of Dr. McEwen. There was no error by the trial court in determining that the complaint was to be dismissed due to claim preclusion. Three points this afternoon, some of which you've already touched upon. Number one, the fraud and concealment claims, which comprised the complaint that was dismissed, arose out of the same transaction as the underlying initial claim. Number two, while fraud and concealment can be an exception to claim preclusion, it is not available where the the concealment or fraud, alleged fraud, was known at the time of the initial action, and there's no dispute that's the facts here. And number three, the reliance upon Chase versus Kern is unavailing, as that case did not involve analysis of claim preclusion. It analyzed a claim of concealment and whether or not it fell within the medical malpractice tribunal statute and the statute of repose, very different considerations than what's presented here. I would submit that I believe this is a straightforward application of the principles behind claim preclusion. The only element in dispute, according to the briefing of the appellant, is the identity of the cause of action. As this court noted, the test that applies there is whether it rises out of the same transaction. It's a pragmatic examination. You don't look at labels or theories. You look at the facts of the two claims, and you examine whether they're related in time, space, origin, and motivation, whether the two cases form a convenient trial unit, and whether treating them as a single unit conforms to the parties' expectations. And when you look at those three criteria, it's inescapable that claim preclusion applies.
You kind of left out the seek redress for the same wrong.
Say again?
You kind of left out the seek redress for the same wrong.
The standard is in terms of arising out of the same transaction. While some language say if it's a different wrong, it may not follow within preclusion. But I believe that the operative test remains whether it arises out of the same nucleus of facts. And even in this case, where the theory is one of fraud, that is a pecuniary loss versus the underlying malpractice, it still arises out of the same facts. It was known at the time of the initial action, but was not brought. Now, while Mr. Hayden has expressed in response to the court's question as to why he didn't bring it, lack of knowledge that that was a viable claim, that's not a sufficient excuse to overcome the prudential concerns surrounding claim preclusion.
The why doesn't bear one way or the other, but the underlying question is whether the claim itself is of a nature that would be barred. How do you respond to his invocation of Judge Cass's opinion in Bradford?
Well, I understood Bradford, I'd have to look at it, is that those facts were not known at the time of the initial action. And here, again, he was aware.
It's not the way I read Bradford. I read Bradford to say that the facts themselves, I mean, that was a factor. But there also was a view that the facts did not overlap that much with what would have to be tried on the other related claims.
Okay. Well, here I would say that there is substantial overlap. Let's start with the basics. Fraud that you allegedly concealed this patella tilt portion of the knee surgery. You concealed that by not disclosing it in the operative report, telling me in post-operative visits, and so forth. The operative facts are still the relationship, doctor-patient relationship. It still involves the surgery. It still involves the post-operative treatment care. The theory that it's pecuniary loss versus personal injury doesn't get you far, because in order to collect on the fraud case, you would have to eventually show that there was inadequate medical care or you wouldn't have any damages. So I don't think it's a sufficient distinction to take it out of the prudential concerns that predominate claim preclusion. He certainly had the ability to bring the claim, and as far as expectations of the parties, treating two actions as one unit and whether it conforms to the parties' expectations certainly met here, where it was known that he had the claim. All the facts that underline this concealment claim were known, and in fact, as Judge Diffkoff mentioned, he in fact in the first action alleges concealment and lack of disclosure. So the clear expectations of the parties would be that all claims would be brought.
Not only alleged it and displayed knowledge, but it bore on one of the other claims that was in that complaint, namely the emotional distress.
True, but the underlying fundamental fact of a non-disclosure was a known and aware, and again, we're back to not appreciating that there's a potential concealment theory is just not something that excuses a party from claim preclusion. The Chase versus Curran case decided by this court, again, did not address claim preclusion. It was a medical malpractice case that during the course of discovery, the claimant learned of additional malpractice that was not disclosed in the medical record and added 2 more defendants, both on a negligence theory and a fraudulent concealment theory. And as you know, the negligence claim was dismissed for statute of limitations, but the fraudulent concealment was allowed to proceed. This court found that was a viable claim because it didn't fall within the terms of the medical malpractice tribunal statute or the statute of repose. And again, as this court pointed out, not only do you have that distinction, but you have the fact that it was in fact brought in the initial action. So you didn't have a claim preclusion problem in a query whether if it had been brought as a separate action, it would have been barred by claim preclusion. And again, I mentioned in my brief, the restatement of judgments has a section on fraud exception to claim preclusion. It's on section 26, comment J. This court, in a handful of decisions, has examined that provision. The Gloucester Marine case, the Miller decision, O'Connell versus White, and Massaro, all mentioned in my brief. And while it's a viable exception, that is concealment, misrepresentation, or fraud, it is not available where the party is aware of those underlying facts at the time of the initial action.
Well, that's the reason for the exception.
True. But I don't believe that, and the bottom line is that this is, the concealment allegations all arise out of the same nucleus of facts, and there was an obligation to bring it as part of the initial action. It wasn't, and therefore claim preclusion applies. And unless there's any other questions, I would otherwise rely on my brief.
Seeing none, thank you both.
Thank you.
The next 2 cases on our list are both impounded matters, and as counsel present their arguments, I will remind them to refrain from reference to any of the names, refer to the individuals involved in the case by their status in the case, mother, father, child, grandmother, etc. The first of the 2 cases is case number 2022 P1100. This case involves a petition for guardianship.
Good morning, Your Honors. My name is Jean Kaiser, and I'm here on behalf of the appellant mother who is here in the courtroom with me today. And she asked this court to reverse the judgment of the probate court granting guardianship of her daughter to her grandmother and uncle. This case must be reversed because the probate court, when presented with a difficult family problem, imposed an unconstitutional solution. Specifically, the court granted guardianship in the absence of clear and convincing evidence or any real evidence of the mother's unfitness. It's extremely well established that the guardian's burden is not to show that the parent has some flaws or that the parent has made some decisions that the guardian disagrees with, or the trial court just disagrees with for that matter, or that they're superior caretakers for the child. They must show that the mother's deficits are so bad as to put the child of risk of serious harm. And you can scour this record and scour the child's brief and not find any evidence or allegation of serious harm to this child. So this court needs to be clear that when a child resists going home after she's been with another person for a while, guardianship is not a problem-solving device for that problem. Rather, there needs to be evidence of serious harm that would be inflicted by the parent, and if the allegation is psychological harm, then there needs to be expert testimony to support that allegation. And each of the cases that the trial judge relied on as support actually either implicitly or explicitly makes that point. In each of those cases, there was some form of expert testimony.
It's not clear to me. I understand the point you're making at some level, Attorney Kaiser, but it's not clear to me that they turned so much on the nature of the evidentiary presentation as the source of the emotional injury. Because in each of those cases cited by the trial judge, the source of the child's estrangement from the parent had a foundation in what we would ordinarily and traditionally consider indicia of unfitness or a finding of unfitness. None of those cases, as I read them, involved a circumstance where the child's reluctance to live with the parent established, standing alone, parent's unfitness. And as I read the trial judge's rationale, that's the part that seems to me to be the most challenging aspect of it.
Well, I think that the child's reluctance to return home is a significant, for lack of better word, practical problem.
Sure.
But it is not indicia of the...
More than a practical problem. The other, just to put all my cards on the table, not all of them, but many of them, as I look at this case, there's a serious question about how to move this situation forward in a productive way for this child. And I'm sure you've wrestled with that.
Absolutely, Your Honor. And I think what has to happen here is not for the court to somehow shoehorn the definition of unfitness to fit a case in which, now the child has not said, I'll be devastated, I will experience great distress if I go home. She said, I'll be unhappy, I'll be upset, and there's no other evidence that it would have any...
That's not quite true, because in June 2020, when the child was considerably younger, the guardianship ended and nothing happened. The child stayed with the guardian and didn't go back to mom, and mom was unable to reestablish a parental relationship. Why is it going to be any different now?
Well, Your Honor, I think that what happened there is where this case took an extremely wrong turn, and that is the trial court had found that the mother was not unfit, had provided a transition plan for the child to return home, and the child said, well, I don't want to return home, and the guardian said, you don't have to. And they went back in to the trial judge, and the trial judge said, okay, you don't have to. And what should have happened there, and it's going to be a lot harder now, and it's going to be rocky, there's no question about that, but what should have happened there is for the trial judge to say, well, the mother is not unfit.
So all we have to do is go back and undo that, right?
Well, right, you can't undo 3 years of damage, but by the same token, you cannot continue a legal error that occurred 3 years ago by finding unfitness because the child has said, we don't give in our law a 12-year-old or a 13-year-old or a 14-year-old or even a 15-year-old the right to decide where they're going to live. If their parent wants them to live with them and they are not unfit, as I would argue is very clear on this record that this mother is not unfit, then the child lives with the parent.
I don't know enough about the entire panoply of legal frameworks that would guide alternative dispositions. All I can do for the moment, as best I can, is to try to assess this case within the framework that was applied. And as you point out, the framework here starts as a threshold matter with a determination of whether the parent is unfit.
That is correct. And again, I would say that there was not clear and convincing evidence. And again, this is the petitioner's burden.
Let me put my cards on the table, as long as we're putting cards on the table. The judge had to figure out, regardless of all the missteps that happened earlier, the judge had to figure out on May 17th, 2022, whether the mother was unfit at that point. And one way of looking at that is, what would happen if you end the guardianship? And the answer is, the mother bartends Tuesday, Wednesday, Friday, and Saturday evenings, cannot do full-time parenting, does have no plan for how she would manage her work schedule, doesn't know where they're going to live, doesn't know whether they're going to stay in Amherst or move somewhere else, and has absolutely no plan for restoring the mother-daughter relationship. Every time she was asked, her answer was, when the guardianship is over, it will just return to how it was before. So when you're faced, regardless of how we got in this terrible situation, when you're a judge faced with that situation, with a mother who has no plan whatsoever on what happens when she gets the child back, isn't that a sort of unfitness?
Absolutely not, Your Honor. And I'm going to take your question in two parts. First,
Please
with
do.
regard to the mother's
cards,
work
I understand.
schedule and where she was going to live. The mother had a busy work schedule. Parents, single parents, have busy work schedules. That does not make them unfit. They can make plans, they can arrange to care for the child. In this case, the mother might well have reduced her hours if the child returned home. The assertion that the mother didn't know where she was going to live, the trial judge is concerned that maybe the mother will move in with the boyfriend and that the child will have to change schools. Well, parents, fit parents, make those decisions all the time. That is not a sign of unfitness. As far as the mother's plan to reestablish contact with the child or to solve the problem, the mother was put in a position where the child basically refused to have contact with her most of the time. The guardians definitely facilitated her unwillingness to have contact with her. Really, the only time the mother got to see the child was in these family situations where she was with other people or in therapy, where by the therapist's report, the child just really didn't talk. And so therefore, it was entirely reasonable for the mother to believe that the only way to repair this relationship is for the child to be back with her, because then they could start to rebuild it. You know, the trial court thinks, well, they can rebuild the relationship if the child stays in guardianship. That's just doing the same thing over and over again. That hasn't worked. And so expecting the mother to somehow repair this relationship with so little contact with the child seems not just wrong, but unfair to the mother. I think it's similar to back in the beginning when the mother asked the child to go to see the Nutcracker with her. This was something they both enjoyed doing. They were both interested in ballet. And, the child says, no, that's too much time. Well, what the mother was doing there, I think, is a time-honored way to deal with adolescent children who are being resistant or being difficult. And that is, get them to do something they like to do, and then spend a lot of time in the car with them. I imagine there are people in this courtroom who have used that method, because when you have to spend a lot of time in the car, you have to talk and you have to start working on that. There really was not, other than for the guardianship to end, a way to repair this relationship. Now, if this court were to, as I think the court absolutely should do, reverse the decision of the trial court and say there's just simply not sufficient evidence of unfitness, so guardianship is off the table. Are there things that the parties could do to facilitate the child's return home or to facilitate the rebuilding of the relationship? Absolutely.
Well, you're not suggesting that it simply be left to the parties, are you?
No. I think the first thing that has to happen here is that the parties have to get the clear message. This problem has to be solved, and guardianship is not a problem-solving device. It is only proper when a parent is unfit. This parent is not unfit. And then the parties could enlist a mediator. They could enlist a therapist to help ease the transition home.
That would be, I take it, under your view, you're leaving the probate court out of this discussion of forward-looking mechanisms.
Well, obviously, the case would have to be remanded to the probate court.
I want to focus. You've got 3 minutes left. I want to spend a little bit of time focusing on how, in your vision, this would proceed. Because as I understand things, the trial judge who heard this case either has retired or is about to retire.
Well,
so walk me through not just the concept, but the mechanics from your perspective.
Okay, so I think, and again, Your Honor, I may not have every step perfectly because I only do appellate law, not probate court law, and most of the appellate law I do
We're
is
dealing with a
juvenile
child
court.
here who is in need of a forward plan.
Yes,
And
so-
I think as a team, we need to think through how all this is going to work. It's not
So-
just enough to talk about legal principles.
Okay, so what I would say, if this court issued an order reversing the judgment of the probate court, I think it would be best if this went to a different judge anyway, because I think that the trial judge in this case had some...
We're probably going to go over time, I think, but I don't understand. If there's insufficient evidence that the mother's unfit, then why isn't our response to issue an order requiring the guardianship petition be dismissed? And that's the end of it. I don't understand what we'd be remanding for if we accept your main argument.
Yeah, I think I misspoke when I said remand. I think that it should go back with an order that the guardianship be dismissed, and then the probate court has to do that, and then at that point, there could be help enlisted, or not.
Help from who?
Oh, yeah.
If the case is dismissed, I think
longer
the
in court.
court's out of it.
Well, that's right, and then I think it will be the parties that will have to work it out. But I think that the problem here is...
I'm not saying that's the answer, but if that's what it seems to me. So if there's a different answer, I need to know what it is. I'm not trying to say, like, I think this is what it is. But that's what it would appear to me.
I'm sorry, Your Honor, I'm not quite sure
He's
which
saying
answer you're
I'm
saying.
not trying to dissuade you from telling me some way in which the court could still be involved, but I don't see it.
Where it's not immediately obvious. And what Judge Dickoff is doing is similar to what I'm doing, which is struggling with, it's one thing to declare that this guardianship was improperly imposed, but that doesn't tell us what happens next in any way that promises productive action.
Your Honors, I think that this court could send it back to the trial court with an order that the guardianship be dismissed, and that the probate court could facilitate any transition plan.
On what basis? If there's no longer, doesn't the dismissal of the guardianship petition deprive the court of jurisdiction?
Well, and then, Your Honor, if that is the case, then the solution is that this goes back with an order for the guardianship to be dismissed, because what can't happen is for a fit parent to be deprived of the custody of her child because of a practical problem, that's where I began, and that's where I will end because my time is up.
I thought the statute said if you deny guardianship, the judge can still make some orders. I can't remember what it says about those, but I thought there was something like that.
Well, and Your Honor, you may well be right about that, and because when the guardianship was initially dismissed back in 2020, the court did make some orders. It made orders that the mother get a psychological exam.
Guardianship wasn't dismissed, it was
It
simply
wasn't dismissed,
denied.
that's correct. It
The
was
matter
continued.
remained
It was
open, and
continued.
maybe that,
Right.
that posture is what you're asking us to restore.
That is feasible. What I'm definitely asking you to do is to make it clear that there was insufficient evidence here that the mother was unfit, and so therefore granting permanent guardianship to the guardians was improper.
Do you have any further questions? Okay, thank you.
Good morning, Honors. Jennifer Wang, represent the child. I ask the court to affirm the lower court's decision and to allow the child to remain in her current home with maternal grandmother, where she has spent more than half of her entire life now.
Attorney Wang, let me just establish, for starters, the foundation or the platform that we're operating on. Do you agree with Attorney Kaiser, that the central foundation of the judge's rationale for imposing the guardianship was that the mother was unfit by reason of the child's unwillingness to live with her?
I think that's one of the reasons.
What are the
I-
other bases
I-
that would establish the mother's unfitness?
I disagree that's the sole reason to establish a mother's unfitness. The judge findings, Your Honor, indicated that in a fair level of detail and specificity, that mother could not historically keep a safe and sanitary home environment for the child. For example, that's one.
That was on one occasion in, I forget what month it was it September of 2019?
Correct. That's
Okay.
before the trial started.
Right.
And I think the findings indicated that
There was-
mother's pet of guinea pigs were left without food or water, and they were found in a state of near death. And there are multiple bottles of empty vodka was found in mother's apartment. There's also mother's bed sheet were covered with red wine, and grandmother spent entire 3 days to clean for mother.
At the time of trial on this guardianship, was there evidence of substance abuse?
The judge did not make that finding because at the time the mother was living with the ex-boyfriend. This was the boyfriend who attempted to kill mother, according to mother's testimony. So the judge could not determine whether the alcohol use was due to mother or the boyfriend. But either way, there is alcohol found in the apartment. And there is also, if I may, continue that thread, the judge also established that there is a pattern of instability in regarding mother's parenting. For example, mother's employment history. The judge made findings that mother has been working at Lord Jeffrey Restaurant, Osteria Vespa, Italian, Miss Saigon, Thai Restaurant, Porta, VFW. There is church, food pantry, chambers of commerce, Sally Beauty, Boys and Girls Club, and she has taught dance, waited tables, she worked at art gallery, she worked at a bartender.
This is evidence of
So?
unfitness?
It's just on and on. Yeah, this is mother's
Because she's,
employment.
but she has maintained in a very volatile hospitality industry through a global pandemic, continuous employment at 40 to 50 hours a week.
Correct, but
That's evidence of unfitness?
yes, historically, in addition to the employment history, and I don't want to go on and on, there is also instability of mother's housing issue. So the transcript and also the judge's finding established that mother has been bouncing from apartment to apartment and place to place. She was evicted from Section 8 housing, and then she moved from Amity to Lincoln Avenue, from Lincoln to Grandmother's Avenue, from grandmother's house to
When we see
Shoemake.
quite a number of cases involving petitions by the Department of Children and Families to terminate parental rights based on parental unfitness. And in those cases where the standard is essentially the same, the nature of the unfitness involves far more egregious shortcomings than what you've just inventoried here.
Yes, Your Honor. I think the critical inquiry is whether, although I am acutely aware of the significance of parental rights, although it's a guardianship, a mother could still do therapeutic work with the child and her rights were not terminated. But as child counsel, I'm also cognizant of the enormous responsibility tasked on me to make sure that the child's concerns are validated and her voice is heard and her wishes is weighed by the court.
Let me ask you this,
Yes.
just to get back to this question of unfitness, because it's not quite clear to me. Can a court consider the mother's failure to take steps to bond with the child as a measure of unfitness? And the reason I ask that is this. The judge seemed to go into some great detail about living arrangements and so forth, that for the first 4 years of this child's life, mom worked 80 hours a week, which left the grandmother to be the most significant caregiver, feeding the child, clothing, bathing, transporting to school, and so forth. It was only then that they moved out of the house, the grandmother's house, for a period of years, and mom moves in with 2 male housemates who upset the child. It was not a good arrangement. At one point, she went on vacation during the pandemic without the child, went off with her boyfriend and his children. Child didn't want to go, and she just left the child. So there seems to be at some points, a lack of an effort by mom to make a bond with this child. If that is so, are those valid considerations as far as the question of fitness goes?
Absolutely, Your Honor. I think Your Honor raised a very good point that, so there's the lower court judge default position was to, if you recall, at the early stage of this case, the judge ended the guardianship and give custody back to the mother. And what transpired after that was very telling. So mother, instead of spending time with the child, she decided to go on vacation with the boyfriend and left the child behind in Massachusetts. And 3 weeks later, when mother back, the child doesn't want to go to mother's place. And mother called the Amherst Police Department. The police showed up at maternal grandmother's house to take the child. And no child should have to live in that kind of conflict and chaos. So the default position of the judge didn't work. And she considered a range of reasonable alternatives, trying to see whether it can give.
I'm not sure I quite followed that. So we have a child, there's no guardianship. She's in the legal custody of her mother.
Right.
And her mother wants to take her to a place or a house. Why does the child have any say in that?
Right, exactly. So the child should have some say to that. The child refused to go to mother's house following June 2020 after the guardianship is returned to mother. And it doesn't take a lot of imagination to predict that if this happened again when the judge, hypothetically speaking, if the judge returned the custody back to mother. Mother will have custody, and the child refused to go, then police will call.
Right, but if a 12-year-old refuses to go home with their parents, what do you think should happen?
Right. So I understand the sentiment of mother that teenager going through emotional phase, turmoil in their life, and sometimes it's not unusual for teenagers to engage in rebellion, and sometimes they might even use the preference option to escape discipline, but that's not the case here. I was combing through the record. There is no evidence to suggest that this child had any behavior
Our
issues
focus
or
is not on the
behavior.
child's motivation. Our focus is on the mother's unfitness.
Yes. Yes, I would like to focus on mother's unfitness, if I may. At the time of trial, mother continued to struggle with her emotionally troubled past. And the transcript that mother testified herself, it's on transcript page 360. Question: you refer to your mother by her first name? Mother. That is correct. Question: is that right? Why do you do that? Mother. Because I do not consider her my mother, and her name is impounded. Question: well, by not considering your mother to be your mother, do you feel that is disrespectful? Mother. No. So it's easy to...
Well, that
Oh, yeah.
suggests that the tension between mother and daughter is intergenerational.
Right. So mother's anger and resentment towards her family members at the time of trial still there,
That does
very
not,
strong.
but that doesn't
So?
render mother unfit as a parent.
It hurts the child in a way that sentiment, that anger, and that resentment would perpetuate the fragmentation of the family. And if I can share with the court from the child's perspective of what's going on, why she is reluctant to go home. This case reminds me of a famous Chinese saying called 杀鸡杀猴. It literally means to kill a chicken in front of a monkey, and the monkey would be terrified. Now, in the context of parenting, when children witness domestic abuse or domestic violence, they don't have to be the target or the victims to suffer harm. And the child clearly told the judge in chambers, clearly saying that she was hurt. She described to the judge that one time, mother was, at a parenting time, mother was throwing F-bombs towards the grandmother, the type of language that I can't really repeat in court. And then
Get the picture.
mother just walked away, and the child said that she was hurt. So when children witness, I'm sorry, my time is winding down. I just asked, I believe there is clear and convincing evidence that mother was unfit, and asked the court to affirm the lower court decision. If there's no other questions, I would rest on my brief.
Thank you.
Thank you.
Brings us to the sixth and final case on our list this morning, case number 2022 P588. This is another impounded matter, and again, following the protocol in the previous case, refrain from references to any names, refer to the individuals as by reference to their status in the case. I understand that on the appellee side of this case, the attorneys will be dividing their time equally, 7.5 minutes apiece. Attorney Casella?
Yes, good morning. I am Attorney David Casella from Brockton here for the appellant guardian.
My first argument, Judge, is that guardian contends that visitation between the minor child and the guardian should have been ordered, and that the court abused its discretion in not doing so. Very clear.
There is no liberty interest or other entitlement for presumptively awarding guardian visitation to a guardian, is there?
No, there is not. However,
It is permissible for a judge to authorize or even to order visitation where it would advance the best interests of the child. And you're suggesting that in this case, the circumstances were so compelling that that it was an abuse of discretion for the judge not to do so.
I am, Judge.
As I read the judge's rationale, at least a portion of the support for the judge's decision, at least in the judge's eyes, rested on the fact that the guardian would have regular contact with the child during the mother's parenting time.
I can address that if you wish to.
Please.
I'll do it right now. The sole reason, from my reading of the judge's decision, why visitation was not granted was exactly what Your Honor is saying, that mother had testified credibly that she would allow the child to be with a grandmother with guardian. The problem is that after a review of the record of the actual testimony related to what mother said on this particular issue, mother was extremely, extremely non-committal.
If it's my responsibility to make sure she has time, then I'll do that. If she didn't have any designated time, I would bring her every other weekend. What's equivocal about that?
The words, "if it's my responsibility."
Well, it's going to be her responsibility because there's no visitation ordered for the grandparents.
There would be no order or decree compelling mother to allow the visit or to allow any visitation. So when we look at the testimony from mother, mother says, I would hope that she would just get time. If not, then would that be my responsibility too? Then she says, if it's my responsibility to see that my mother gets time, I will do that. It is not her responsibility at this point in time. And further evidence presented indicates that mother actually testified that she had not even had overnight visits with this child. So it's the same sort of
What happened with the custody dispute between the mother and the father?
I don't know. That was a separate matter. My very poor knowledge of what happened with that particular case, because we had multiple cases joined together and heard at the same time, including between mother and father. I believe that mother was awarded some visitation, but I cannot say that for certain. One of the arguments of other counsel here was that, well, the rights of the child were also protected because father was going to guarantee that the child would be able to see the guardian. This is not the case. If we look at the actual testimony of father, what father said was that he anticipated guardian having visitation with mother together, that he actually wanted mother to be under the supervision of guardian because of mother's situation, history, etc. So there was absolutely no guarantee that the guardian, who this court, the lower court, specifically said had been the primary caretaker for this little girl for most of her life and had established very strong bonds with her. This is the essence of the case on this issue, is extraordinarily strong ties between guardian and child. Extraordinary. Did everything for that kid. Lived with, took total care of her. And any indication that, or any representation that the other grandparents were equally as involved was not supported by the record. The judge found that substantial relationships existed between both grandparents here, of course, but that it was my client who essentially raised that kid. So, again, a close reading of the testimony is precisely what I have said, and that is the judge indicated that the only reason why she wasn't ordering it is because Mother had testified credibly. Mother did not testify credibly. Mother said if it was her responsibility to do it. Well, right now, Mother has no responsibility to do it, and that's my point. That's my point. I'd like to now talk about guardian's contention that there should have been a guardian ad litem appointed on this case, if I may. The court denied guardian's request September 19th, 2019, to appoint a guardian ad litem. We contend that the denial was an abuse of discretion. We contend that it was an abuse of discretion because in looking at the facts that I set forth in my brief, it's very clear that there's something very wrong with the decision of the judge here. We have a minor child. It's indisputable that the minor child was a 6-year-old girl. And again, this is all at the motion hearing, from which we must judge the lower court's decision. This is what was presented to the judge at that particular time. Mother was concerned and supported the appointment of a guardian because of her concern for sexualized behavior on the part of the child. The guardian informed the court that the child was talking about dead people and exposing her breasts and talking about hurting herself and hurting others, and that the child had returned home from a visit with the paternal grandparents and father, reporting disturbing information about viewing a television program showing a naked man.
Our standard of review for assessment of the propriety of the judge's decision is abuse of discretion on this, right?
It's an abuse of discretion analysis.
And the purpose of a guardian ad litem in a proceeding of this sort, whether to have engage a third-party investigator of any kind, is an optional discretionary determination by the trial judge in the first instance, right?
Subject to a review by this court.
Right,
Yes,
of
Judge.
course. The purpose of having a guardian ad litem or an independent investigator or a special master is what?
It is to investigate and report to the court. Certain guardian ad litems, of course, specialize in.
I understand, but I mean,
things.
all of this is in furtherance of the ultimate task of the judge to make a determination on the merits of the guardianship petition.
As to what is in the best interest of the child.
And in the ordinary course of adversarial proceedings, it falls to the parties to gather and present evidence and on all the questions that bear on the guardianship petition, and the judge would, in the ordinary course, as in any other adversarial proceeding, assess the evidence as it came in. In a proceeding of this sort, courts often take advantage of the independent investigator to augment the presentation by the parties. Is that the goal?
When you say independent investigator, do you mean the probation officer, Judge? Is that who you're referring to?
Whether it's a special master, whether it's a probation officer, whether it's a guardian ad litem.
Yes.
I mean, I'm looking at a functional approach
Yes.
to what it is that this entire exercise was all about.
Yes.
Okay. And so the goal here was to get someone other than the parties to gather evidence from an independent perspective and present it to the judge so that the judge could, at the end of the trial, conduct an adequate assessment of the circumstances bearing on the guardianship petition?
I think that the goal here would be to appoint the most qualified person, if possible, to conduct such an
Well, I
investigation.
mean, certainly you want someone who's qualified if you're going to get into
Which
the
in my
exercise
opinion-
at all.
Which in my opinion doesn't matter. In this case, as Your Honor knows, the probation office was tasked with this particular investigation. The probation officer was also prevented by the judge by a subsequent clarification order from even speaking to the child, even though so much of the original information underlying the request for the guardian ad litem pertained to experiences unique to the child, what she was saying. So in this particular situation, we have the probation officer not being allowed to talk to the child, and he wanted to.
By the judge?
I'm sorry?
By the judge?
Yes.
Yeah. So that, I mean, but that is separate and apart from the appointment of the probation officer in the first instance, right?
I saw it as that after the request for a GAL was denied, that the court then tasked the probation.
Right, but I mean, you would have the same concern if the judge had prohibited the GAL, had appointed a GAL and then prevented the GAL from speaking to the child.
I would have, but my concern with the probation officer is that the function of a probation officer operates very differently from an independent guardian ad litem. Specifically, the probation officer works for the probation department. The actions that are taken by a probation officer must be and are under the direct supervision of his supervisor. So there are also budgetary constraints as to what a probation officer...
That's certainly true in the main, but within the narrow confines of this appointment, the guardian ad litem or a probation officer or a special master each would be tasked with the same directives underwritten by the judge, who, of course, in the trial setting, is the ultimate authority on how to gather and regulate the process toward making a final decision.
This is correct. However, a guardian ad litem, in my experience, and I believe in actuality, is a much more powerful type of an investigator, because the guardian ad litem doesn't have to ask anybody to go back into court and report to the judge earlier saying, I need this, I need that, I want to talk to this child, here's why. There are new developments occurring, here's what's happening, I need to dig here, I need to dig there. In reality, probation departments are not as freewheeling, if you will, as a...
Is there any indication that the probation officer assigned in this instance sought approval from superiors but was denied that approval to go back into court seeking additional leeway?
I have no information of that nature.
Let me ask you a practical question.
Certainly.
This probation officer wrote up a 30-page comprehensive report. This information was all before the judge. There's testimony. The ultimate recommendation was no change in the guardianship status, right?
Yes,
so,
that's correct.
All very favorable to the guardian's position. So, what would a guardian ad litem bring to the table that hasn't already been brought to the table by the probation officer?
Well, first of all, it's my memory here that the judge admitted the probation report in full, but for and struck the recommendations of the probation officer. So that was off the table. I don't know whether or not a judge would have done a similar thing with the guardian ad litem. I also don't know what I don't know, because I don't know what the nature of an independent guardian ad litem would have been. I know that in reality, again, the guardian ad litem is able to take matters into their own hands in a much freer manner and doesn't answer to anybody but the judge. The probation officer has his superior and also has and also the judge. So I don't know what I don't know.
Why don't you have to show that the judge's misstep prejudiced your client? If you just don't know whether it did, how do we reverse on that?
An excellent point. I don't know ultimately, but I think that the point is that the child deserved, in my opinion, an investigation that was as broad and as competent as it could be, so that protections could be brought to bear. And I truly believe that the guardian ad litem would have been a much more preferable choice than the...
I see that your time has expired. I think we'll have to leave it there.
Thank you, Judge.
Thank you.
Good afternoon, Your Honors. May it please the Court, I'm Catherine Foster on behalf of the father in this matter. The central issue in this case was fitness. And the Court properly focused on father's fitness. There's a constitutional right to parent, and guardianship is only a substitute arrangement when a parent is unavailable to do that. In this case, because father was never the subject of an unfitness finding, and because he assented to the original guardianship in 2017, he wasn't really required under guardianship of Kelvin to prove that anything had changed, but he did. He proved to the court that he had attained sobriety, to the extent that on the first day of trial, at the end of the day, the court indicated to father's counsel that he'd met his burden. He supported his fitness with credible testimony about his sobriety, about his decision to pursue sobriety, the programs he participated in, what he learned, that when he experienced cravings, he sought professional help and received a referral to Clean Slate. This testimony was further corroborated by hair follicle and urine screens from Clean Slate that confirmed that father was drug-free from the date February 2019 that he claimed as his sober date. His testimony was further corroborated by testimony and notes of a visitation supervisor who witnessed 20 hours of interactions between he and his daughter, by the testimony and, as Your Honor noted, the lengthy report of a probation officer who, although he did ultimately recommend that the guardianship stay in place, also found father's report to be fairly forthright and accurate, and never noted him to be impaired in any way. After finding father unfit, it was the guardian's burden to prove that father was unfit and that it was in the best interests of the child to remain in her care. Unfortunately, the guardianship suffered from a credibility problem that began at the beginning of the case when on June 25th, 2019, the guardian represented that the child reported basically the opposite of what the child had reported in a DCF report to the court, leading the court to make an order for supervised visitation for father. On October 25th, 2019, the court took the unusual step of vacating the first two paragraphs of its order and explicitly noting that it was because of the guardian's mischaracterization of the facts to the court that led the court to make the supervised visitation. Unfortunately, the guardian continues to push that same mischaracterization throughout trial, even until the reply brief, even though throughout the case, the court noted that it was a complete distortion. Guardian didn't provide any additional evidence to support that alternative narrative of the case. And it was within the court's discretion to not believe the guardian's version and to instead credit father's testimony and the testimony of the visitation supervisor and the probation officer.
Counselor, do you know what happened with the mother-father custody dispute?
There is, it's my understanding that there was a judgment for parenting time. I know it's included in the record. It was on March 15th, I think that might be a mistake, 2021, I believe. And it,
So in the March 15, 2021 decision, the judge says, I'm going to hit mother-father custody later. I assume that's happened, later has happened, so.
well, there is a judgment for parenting time.
I understand, but the judge says, I'm going to revisit mother-father custody in that March 2000. I mean, if you don't know the answer, it's fine, but the judge said they're going to do more, that she was going to do more stuff on custody after March 2021. I want to know what happened with that.
So on the complaint for custody support and parenting time, on March 15th, 2022.
Oh, 22, I'm sorry, I thought you said 21.
The original decision was 2021, and then there's a judgment specifically for parenting time. That's okay, I think I probably misspoke. But it does discuss the parties, during summer vacation, parents shall have alternate weeks. Mother is going to have alternate weekends with the child. So the judge did make a determination about parenting time as between the parents, and it is included in the record.
And that was, I'm sorry, just in terms of the sequence, that was prior to the decision on guardianship or after?
After.
Yeah. Okay.
So it looks from the record that it was exactly 1 year in between the decree for the removal of the guardian and the judgment for parenting time.
But for present purposes, in evaluating the impact on both the child, of the reliance on shared parenting time between mother and former guardian, we may refer to that subsequent order on custody to have an understanding of what's going on.
Yes, it's complicated, Your Honor. There have been additional
Adjustments?
There has been additional litigation between the parties, and that's all on mass courts. If Your Honors were interested in taking judicial notice of those things.
We have resort to the record of the case, and we can review that.
Okay. But it would be appropriate for the court to take note that father was always willing to grant the guardian access to the child, never wanted to separate the child from access to the guardian, but he did want to parent his daughter. And so his interest in removing the guardian was so that he could parent his daughter, he could have control over her medical decisions, he could, be with her and make those parenting choices that he was entitled to make. But he always envisioned including her extended family, including the maternal grandmother in her life as visiting resources. In fact, the guardian notes in her brief that father didn't object to a visitation order if it was to be entered on behalf of the guardian.
Right. Thank you. We'll hear from counsel for the child.
Thank you. If it please the court, my name is Christine Hamilton-Quiros. I represent the appellee child, and she is asking that the court leave the court's findings and the lower court's findings and determinations undisturbed so that she can maintain permanency with her father, especially where the child bases this request on established law that the lower court's findings are entitled to deference and should be left undisturbed absent an abuse of discretion or a prejudicial error. And where guardian has based her entire appeal basically on her dissatisfaction with the way that the lower court viewed the evidence, this case should not go back down. It should not be disturbed. It should, the findings and the determination should remain intact. The lower court was entitled to view the evidence in the light that the court viewed the evidence, but even if the lower court had seen father's shortcomings as the appellant suggests, as the guardian suggests, the outcome would have been the same, because even when a parent has parental shortcomings, there has to be a connection between those shortcomings and a risk to the child. And not simply a risk, but putting the child at great peril. This is a father who was never found unfit, never agreed he was unfit. The guardian never accused him of being unfit until there began to very great tensions in the relationship after the guardian had been accused twice by the department. There'd been allegations against the guardian of abuse and neglect of the child. So that the outcome would have been the same even if the lower court had said, yeah, okay, this father has these issues, but it has to get to that next step of these issues are affecting his ability to parent this child. And he at no time was not able to provide for his daughter, despite his shortcomings. Not only that, even if the court had found that those shortcomings left him unfit and couldn't care for that child, the paternal grandparents had filed their own petition for guardianship, and the lower court could have said, okay, let's allow that guardianship, let's revoke the maternal grandparents' guardianship, allow the paternal grandparents' guardianship, and then the child they'll terminate the separation of father and
Is there
child.
any indication that that would have happened?
It could have happened, Judge,
I understand in theory it could have happened, but why is that, I mean, why does that bear on our assessment of the judgment that the judge entered?
Because the court has to go through steps when it's evaluating whether to revoke a guardianship, and that is part of the steps, to find whether the parent is unfit. And all I'm posturing is that even if he had been found unfit, revocation of the guardianship.
But we're not here to assess any claim by the guardian that they were entitled to protect an interest that they held. The only question is whether the guardianship was properly terminated.
And the child would say that it was.
The possibility that a different guardian could have been appointed in substitution for this father, I don't understand how that bears on anything that we have to evaluate for purposes of this appeal.
Because the guardian alleged that father was unfit.
Yeah, but the possibility that the father's parents would be appointed as alternative guardians doesn't bear on the father's fitness one way or the other.
It does not bear on father's fitness. However, if the court had seen the evidence in the light that the appellant would like the court to see the evidence that father was unfit, it's not only whether father's unfit, it's whether he's unfit and the separation between the parents should continue. If the father was unfit, that separation could be ended by allowing the guardianship with the paternal grandparents and still allow the child access to father.
If we find the father's unfit, are you saying your client would prefer a guardianship with the paternal grandparents to the maternal grandparents?
Yes, that's her position. That was her position. Yes, there were issues with the guardian. There were allegations of neglect and abuse with the guardians. The child's behavior was uncontrollable. She was biting, kicking. She was afraid to go to sleep on her own at the guardian's home. The guardian had misrepresented facts not only to the court, but to the doctor, to the school. It was negatively affecting the child, and the child's response was to become emotionally dysregulated. The child would like to see the findings and the determinations of the lower court remain in effect, and for her father to be held to make the decisions about contact with the guardian. The guardian never filed.
If I understand what you're saying, if we found the father to be unfit, you would like us to remand for the judge to decide what the proper guardianship is going forward, instead of just giving the child to the current guardian, to the
No, I apologize, maybe I was unclear. The father's not unfit.
No, I know, I know, I know that's your position, but you're trying to, I gather you're trying to tell us what would happen if we somehow disagree with you on that. Is that, am I missing it?
Yes.
Okay.
I apologize. I would like to say, though, that the father, despite the relationship, going to the questions the court was asking of the other parties, that the father, despite the deterioration of the relationship with the guardian, he was willing to give her visits. He recognized that the child wanted to see the guardian, and he does testify, I think it's at T-272, where he would offer the guardian weekly dinners with the child. So he was not in any way suggesting to cut the guardian out, even though that relationship had deteriorated. The guardian, although they would like to be able to pick whether it's a private, whether it is a investigator from probation or a guardian ad litem, that's up to the court. And the court is entitled to make that decision, and the guardian has the burden to show why the judge's decision isn't the appropriate one. It's not to use that person as a fishing expedition, basically. DCF had been involved, had interviewed the child. If there's protective concerns, the DCF is the appropriate investigator for those. And the 2019 denial of the GAL was never appealed. So bringing it up...
Would have been an interlocutory appeal, but ordinarily interlocutory actions are preserved for appeal through the judgment. So, thank you.
Thank you.
That concludes our session. We are going to take a very momentary recess while we shed the robes, and we will come back out and conduct a question and answer session with the visiting interns who have been watching the session today.
All rise.